Hello, everyone. This is Sean Tassi from Husch Blackwell's Higher Education Group. We are excited today to give today's presentation on ED's heightened focus on data security and what your institution should do to comply. Before we begin, I'd like to cover a few housekeeping items. At the bottom of your audience console are multiple application icons for your use during the program today. I would like to take a minute to highlight a few of the key icons for you. If you have any questions during the webcast, please submit your question via the question box. We will try to answer all questions during the webcast today, but if a fuller answer is needed or we run out of time, it will be answered later via email. We truly appreciate audience participation and encourage you to submit questions. If you have any technical difficulty, please click on the help icon. It has a question mark and provides information regarding common technical issues. A copy of today's slide deck is available in the resource list icon that looks like a folder at the bottom of your screen. The program has been approved for Colorado, Illinois, Iowa, Missouri, Nebraska, Tennessee, Texas, and Wisconsin continuing legal education credit. To report your hours in Illinois, Nebraska, Tennessee, or Texas, click on the CLE widget at the bottom of your screen and complete the questions. A recording of the webcast will be available tomorrow for watching and sharing. Once available, a link to the recording will be emailed to you along with a certificate of attendance. Joining me today is Pete Inko. Pete is a member of our Healthcare, Life Sciences, and Education Group and focuses his practices in health law, information management, and privacy and security matters. Hello, Pete.
Hello, Sean. Thanks for inviting me to join you once again for a cybersecurity talk. Appreciate it.
We have over 500 people signed up today from across the country, including presidents, general counsels, security officers, and FSA administrators, to name just a few. We think it's great that so many people across your campuses are paying attention to data security and privacy because, as we all know, it's becoming more and more important every day. Today we're going to cover 4 pretty specific topics. First, we're going to talk about the Department of Education's new stance on breach reporting as it's been reported to us. Discuss ED's expectations for compliance with Gramm-Leach-Bliley Act. We're going to look at a few of the key provisions of the Gramm-Leach-Bliley Act to kind of put the compliance into perspective. And then we're going to review some best practices to comply with these expectations. So let's jump right in and start talking about the new breach reporting obligations or expectations. Up until late last year, it's been generally accepted that an institution that suffered a breach had no real unique reporting obligations to ED. All reporting obligations were governed by other federal or state laws, and those are pretty robust reporting frameworks. As always, there were a few very specific exceptions to that rule, but for the most part, institutions didn't report those breaches because FERPA contained no such obligations, and there really wasn't any guidance to the contrary. Starting very late summer, early fall of last year, we started receiving calls from FSA administrators who were attending FSA conferences and webinars. They had questions because ED had kind of changed its stance, and representatives were telling the attendees that they had an obligation to report any and all data breaches directly to ED. We've provided several links to those presentations here in this slide so that you can review them for yourself if you so choose. And candidly, when we were first kind of notified of this, we were a little dismissive of what was being told to us. But it's clear after reviewing these slides that the new stance is that every suspected breach must be reported to ED on the day it is detected. Now, before we start getting inundated with questions and buried with those questions, I think it's important to say that we're reporting ED's position on this matter. Pete, myself, and others at Husch Blackwell have been having robust conversations about what it means, and we're going to talk about some of those questions and concerns today. But at the end of the day, it's important to keep in mind that this is what we're hearing about reporting obligations. And I know that there are some groups that are trying to speak with different folks in the department to get clarification on issues, but this is where we are today, so it may be somewhat of a little bit of a moving target moving forward. Pete, do you have any comments on that?
Actually, I do, Sean, and you're probably going to hear me adopt the role of the curmudgeon for most of today's presentation. And to echo your comment about we're just the messenger, We're just the messenger here. I should mention that I still have some legal concerns regarding whether Ed's position is consistent or exceeds the scope of its authority under the Administrative Procedures Act. And for the lawyers on the phone, you may appreciate that. And frankly, we wouldn't be doing our job, I think, if we aren't calling out some of these concerns during our time together today. And frankly, I also have some practical concerns and questions as to whether once all these breach reports start flowing into Ed, whether they're able to handle them all, whether they're able to process them all. But obviously, that's Ed's call.
And I'll just say that Pete plays a great devil advocate when it comes to data privacy. So it would be good to get Pete's perspective. Which actually brings us to our first poll question. We want to get this out quickly. Were you previously aware that Ed expects your institution to report suspected data breaches on the day it's detected? Is that information streaming back to you? It would be interesting to see what the attendees are hearing about that.
And while everybody's dialing in or checking in or answering the question, I would call out the fact that we're legitimately interested in hearing your answers to this question because we want to know how far and how well the department has communicated its position on breach reporting.
So we're getting a pretty good list here. It'll show it's what we would expect, that some folks know, not all folks do. Obviously, we don't know, which oh, you couldn't see the results. I see. Thank you. We're getting this is what we think. Some people know, some people don't know. We don't know, which departments know about this at your institutions, which don't. But that's where we would kind of expect those numbers to fall in. So one of the first questions that we're typically asked when we talk about the reporting expectations is where is the authority coming from? And when you listen to the presentations that we've linked, Ed will tell you that one source is your program participation agreement, your PPA, and the other source is your student aid internet gateway agreement, the SAIG agreement. And we've read both of these documents. We're not convinced that it's that clear. For example, both the PPA and the SAIG agreement relate to the administration of federal student aid. But as we stated, Ed's breach reporting obligations aren't limited to FSA data. They're much broader than that. To the extent that every breach is expected to be reported. The position that has been stated in the presentations is that while one breach may not implicate the FSA system, the next one likely will. And that's kind of the position that they've taken. So now at the end of the day, as Pete's kind of alluded to, data security is very important. Data privacy is highly regulated by many industries. And Ed's responsible for overseeing higher education and candidly probably have authority through one way or another to create omnibus breach reporting regulations that every institution must comply with. But there's no really clear reporting framework that we see in these documents. And as Pete indicated, as lawyers, our primary responsibility, we feel, is to understand the regulatory scheme so that we can really help our clients comply with their obligations. And so one of our biggest concerns, even assuming that all these documents require omnibus breach reporting as indicated, that would pass scrutiny is they don't provide clear framework on what is expected. And I think Pete's got a few comments here that he wants to make.
And I do. And before making those comments, I'm going to take off my curmudgeon hat. Although I'm a bit skeptical about all this, and you already heard me say that, if I were going to channel Ed for a moment, I'd say that it is entirely within its purview to contractually obligate institutions to adhere to this strict reporting regimen. I'd also point out that all legal, all practical issues aside, this particularly assertive posture the department's taking may actually be doing many of our institutional clients a favor, as it essentially drives them towards a better posture, creating a culture of information compliance or information privacy and security compliance. And if an institution's behind the curve when it comes to cybersecurity compliance, it's going to need to move very rapidly not only to achieve these new requirements coming out of ED, but also what the market's going to drive. And, to that extent, too, I think this position does foreshadow where the market is going with respect to information privacy and security compliance. And it very well may be that the department is or has beat the cyber insurances or insurance carriers to the punch when it comes to moving the needle to a more compliant environment. So with that, Sean, I think it's back to you.
Okay. So let's look at exactly what we know about these reporting expectations from the FSA presentations, what we've distilled from those. First, what are they calling a breach? And the definition that's been used is any unauthorized disclosure, misuse, alteration, destruction, or any other compromise of information. And candidly, that's a pretty standard definition of a breach, and one that I think most privacy professionals would be okay with. But note that the reporting expectation isn't limited to breaches. It's actually tied to suspected breaches. And the use of the word suspected breach makes us nervous because that's a departure from other U.S.-based breach reporting frameworks. Typically, you would only report a confirmed breach, not a suspected breach, and we don't have a clear standard as to what suspected means. Now, Pete's going to talk about this in a minute, but there's typically an investigation involved when looking at our security incidents to know whether there's even been a breach or what you'd consider a suspected breach. So it's kind of we're not exactly sure how to interpret that word. Also, there's no clear definition on what information, if breached, would trigger the reporting obligations. So is it education records? Is it non-public customer information? Is it personally identifiable information? And I think that the ED response would be yes to all of this. But these terms by themselves seem a little too generic. Even assuming a term like PI isn't specific enough because the definition of PI varies from regulation to regulation and from state to state. So what's protected in one regulation or scheme may not be protected in another. And I think PI is a good example there because that is kind of a generic term that's widely accepted and utilized in the privacy world. But when you start jumping into reporting obligations and those types of things, you always go to the statutory framework that you're dealing with to see what the exact definition is for that particular term. So from a compliance standpoint, we're concerned that it doesn't have an express definition of what information is being considered sensitive. For example, social security numbers, government IDs, FFA passwords. And without that, it's difficult to know the boundaries of our reporting obligations. And Pete's going to talk about this again in a little more detail, but at core, the purpose of breach reporting, in our opinion, is to stop cyber crimes and prevent identity theft. So over-reporting doesn't really help institutions who are reporting the events, the agencies who are trying to regulate the event, or the potential victims of the cyber crimes.
Yeah, and that's an interesting point. I mean, if we liken what's going on here in terms of breach notification, breach reporting, et cetera, to TSA, when we go to the airport and we're constantly on orange alert, are we ever on orange alert? Probably not. So if we get to a position with respect to breach notification, breach reporting, where folks are getting these types of reports in daily, where agencies are getting these reports in with such frequency that they become meaningless, well, they can become meaningless. And there's a balance that needs to be struck there.
Kind of like trying to drink from a fire hose.
Exactly. Do you mind me kind of putting the curmudgeon hat back on?
No.
Okay. Well, the curmudgeon hat is back on. And could we go back one slide?
Yes. I
got to be honest with you. I still don't understand what this suspected breach means and to what information it applies. In almost every other industry that we service with respect to cybersecurity compliance, there's a degree of latitude, and you've alluded to this already, there's a degree of latitude accorded when it comes to determining when a breach has occurred, when it needs to be reported. And typically that latitude is tied to the likelihood of misuse. the likelihood of compromise, the likelihood of harm to the affected individual. That latitude also has a timing component to it, which allows for a reasonable investigation to determine whether we've got any breach that would affect an individual. So all that said, all skepticism aside, I think the key takeaway from these reporting expectations is that when an incident occurs, institutions should immediately engage their cybersecurity incident response team, which would include your CIO, your CISOs, your risk managers, your attorneys. Get them together. Get them in a conversation about whether a breach is truly suspected. And then if it is, obviously this breach notification or this breach reporting obligation would kick in. I know we're going to talk a little bit about that later, but just wanted to call out and amplify some of your comments. All right, for those of you who listened to our webinar from last August, we discussed strategies for responding to data breaches. And if you recollect anything from that discussion, you'll note that we laid out this particular compliance approach. And according to that approach, when a word of security incident, and notice that I used incident instead of breach, but when an incident comes to the fore, the institution must immediately determine whether or not data has been lost or whether data has been stolen, and whether that loss or theft occurred to an accident or to criminal activity. And then if a determination is made that data is lost or stolen, a second determination must be made regarding whether any reporting obligation has been triggered. That is, has a breach occurred? If so, the institution has to execute on that notification requirement and then take steps to limit the public and regulatory backlash. Now, with this new, or relatively new, requirement coming out of ED, or ED, I work with a lot of emergency departments, with this new requirement coming out of ED, our structure, basically, it's turned on its head to some extent. So ostensibly, institutions now have to, at the suspicion of a breach, notify the department of the incident, giving rise to that suspicion. This disrupts the normal security incident analysis and breach notification process. And this disruption, at least in my mind, is pretty great. And we're going to discuss that a little bit more fully on the next slide. So again, from our presentation last August, we laid out a 24-hour checklist, and we proposed a number of steps which actually aren't all that dissimilar from the approach that is being recommended by ED on this topic. But we proposed a number of steps to take those big picture determinations that we made from the previous slide and put them into a process to determine whether we have a conclusion that a reportable breach has occurred. Those suggested steps include keeping meticulous notes of what occurred, when it occurred, and to the extent that it is known at the time, how it occurred. And simultaneously with that note-taking obligation, efforts must be taken to contain the breach, stop any additional data loss. And I would call out, again, from our prior webinar, that one thing we were really stressing with respect to containing breaches is that containing the breach should not involve unplugging systems, especially if there's any concern, if there's any indication that foul play is involved. If we unplug the system, we lose the ability to analyze the system and determine unequivocally whether a bad act occurred and determine unequivocally who that bad actor is. So we don't unplug systems. We take them offline. We don't unplug them. Finally, but I guess actually just more critically, legal counsel and a forensic firm must be engaged at the start of the process to kick in their legal and technical analysis of the scope of the breach and also any notification obligations that the breach or the incident would trigger. And at the same time that all of this is going on, law enforcement may be alerted, or must be, in most instances, must be alerted if we think that there is a bad actor involved. That allows them to begin their investigation. When we reach out to law enforcement, typically what we get back from them is what we refer to as a law enforcement delay, and that's a directive from the law enforcement agency that no reports regarding the incident be communicated to any other individuals or any other entities or any other agencies until the law enforcement agency actually completes its investigation. What's curious, what's interesting, putting the curmudgeon hat back on, is how the department's position, possibly even demand, that all suspected breaches be reported within 24 hours falls out with these law enforcement delays.
Pete, before you move on, law enforcement can be a little, generic. Who is it that we typically work with when we're talking about the?
Thanks for asking that question. So typically what we do when we have a situation in which we suspect a bad actor, somebody's hacked into our system, there's been a social engineering attack, and somebody has clicked on a link that they shouldn't, we call the FBI. We've got good contacts throughout the country at various locations throughout the country, and we just simply phone up FBI, tell them what has happened, and then they typically issue that law enforcement delay to us. We prefer to go that route because in many instances we find that the FBI is much more sophisticated in its approach to cyber crimes than local law enforcement, and they'll allow us a degree of latitude, to use that word again, in carrying out our own investigation, whereas local law enforcement may get too involved.
And then there's some communication kind of back and forth during this whole time, right?
Correct. It's essential that we check in on a regular basis with the FBI to make sure that law enforcement delay is actually meaningful, that we're executing on our investigation.
I think there's a couple questions on that, so we're trying to hit those. So,
okay. Moving right along?
Yes.
All right. Just like I did with the last set of slides, let's insert Ed's new requirement into that checklist. And as I mentioned, there's some questions here as to whether or how this new process impacts this first 24-hour checklist. So here it is with Ed's new reporting process added. While the department views its activities as helpful to the institutions impacted by a security incident or a breach, I think, as I've mentioned already, it may be overstating its role in the bigger picture. That is, with any security incident, with any breach, a breach involving an accident, a breach involving a bad actor, there are a variety of law enforcement agencies, a variety of regulatory agencies that may be involved. And as we mentioned already, one of those is going to be the FBI. But oftentimes, especially when there's W-2 information, Social Security information involved, we'll pick up the phone and call the IRS as well. So kind of putting this into real terms, let's assume we had a social engineering attack that resulted in disclosure of W-2 or Social Security information. The first two calls that we would recommend as the attorneys for the affected institution would be, one, the IRS, so they can work their magic in shutting down systems so that fraudulent claims, returns, etc. aren't filed. And then the second call is the FBI. And when we call the FBI, we get that law enforcement delay almost immediately back from them. What then, how then are we supposed to deal with this new requirement that the department wants us to call them within 24 hours? One other point I'd call out here is, by reporting to multiple agencies beyond, the IRS and the FBI, we may be finding ourselves in situations where we've blown the privilege. And especially when it comes to forensic investigations, that can be problematic. So and call all those issues out.
And I know you like to play the curmudgeon a little bit, but I think there's other instances too that this is very factually specific, and I think you'd agree with that, where maybe you know that there is an issue with FSA passwords that it sounds like the first call would be the department instead of the IRS, because the IRS would have nothing to do with that.
Yeah, I think you're exactly right there. I mean, it depends on the circumstances. And kind of this harkens back to that comment that we made earlier about immediately when you have a security incident or you're aware that something may be going on that shouldn't be, a security incident, possible breach, you convene your response team, and that team makes a determination.
I think that's good advice. A couple of additional comments about the reporting obligations that's coming from the FSA presentations. Number one, there's no minimum number of records that would trigger the obligation. Frequently when we work with statutory frameworks from state AG's offices or HHS or some of those other entities, they have a minimum number that requires notification to those agencies. It's usually 500, maybe 1,000, 10,000. It really varies depending on the agency. But in this instance, there is no such minimum number. Two, improper employee access is considered a breach if wrong. And then finally, it's not limited to digital information. I think this is important. A lot of times when we talk about data privacy, data security, we immediately jump to electronic documents, and no framework really is confined to that, and it's not here. It's or at least it's more accepted that paper counts too.
Putting the curmudgeon hat on just briefly, again, I'd observe that these requirements, they're so broadly construed, and they do run counter to most other state and federal breach identification and reporting structures. And what I'm most concerned about is that they just don't leave any room for like a risk of harm exception. No harm, no foul, no need to report. All that said, this first bullet point does make sense. I mean, if we've got one affected individual that may run the risk of harm as a result of an inadvertent or advertent disclosure of information, then obviously they should be notified.
So schools that self-report a suspected breach will receive a letter from ED requesting a couple different things. We've helped a couple of schools that have received one of these letters and had communications back and forth. The first request is a detailed description of the incident. I'll tell you that the letter is multiple pages and can be a little bit overwhelming on the first read, but this kind of distills down what's being requested. They're going to want a detailed description of the incident and give you kind of a status update, whether it's complete or ongoing, whether your investigation is. And if you're considering it complete, they're going to want to see a forensic analysis or the forensic analysis showing that the remediation has occurred so that they can look at that. And then they're also going to request copies of some of your institutional policies, two of which being the Information Security Program documents and the Identity Theft Prevention Program documents. We're going to get into more detail on both of those two documents under the Gramm-Leach-Bliley component of this in a few minutes, but wanted to kind of show you how this all ties together, that you're going to have to kind of show your policies in response to that letter.
Can I chime in here?
Please.
Oh, okay, so I want the second bullet point underneath the first heading, forensic analysis showing remediation. It's my understanding that the letter from Ed comes within roughly a month. Is that about right?
I think it varies, and I'm sure that they are inundated with things and trying to do that. So, but I'd say that's probably
okay. So give or take a month. But we know that forensic investigations usually run about 6 to 8 weeks to complete, and that'll vary depending on the complexity of the information, the complexity of the systems, the amount of data. So from a timing perspective, this just doesn't seem to add up, right? We get a letter within 4 weeks. The investigation is supposed to take 6 to 8 weeks. I guess what are we supposed to do then? And I guess my recommendation would be that the most we could do then is at the time that we are responding to this letter, assuming that my time frames play out accurately, is respond to Ed indicating that the investigation is underway and provide maybe a limited status report what we're finding thus far. But all that said, I got to be honest with you, these few requirements here are pretty much becoming industry standard. So I don't see that it's going to throw a huge wrench into the compliance systems of our institutional clients.
And I'll just add that on the timing component of it, they do ask whether you're complete, ongoing, and a status report would be acceptable. They're very accessible as well, providing cell phone numbers and information that you can call and really work with them. So I'll add that they're very accessible with the communication piece of it, Pete. Thanks. For the schools that don't self-report, Ed has stated that the authority that it has authority to fine institutions that do not comply with this requirement. They find out later that you didn't report, that they have authority to fine institutions up to $54,789 per violation. That's coming directly from their web materials again. So that's kind of the carrot that's leading you to the self-reporting.
Sean, where do those numbers come from? I mean, that seems really, really high. And they seem kind of out of line with what other state agencies, other federal agencies are able to assess. And it's interesting, just as one other point, we're going to talk a little bit about Graham-Leach-Bliley in a minute. Under Graham-Leach-Bliley, there isn't a provision for monetary penalties. It's injunctive relief. So where are those numbers coming from?
Well, the numbers that they're providing are coming from 34 CFR 36.2. It's kind of a Cleary-esque model. I think we're all familiar with that piece of it. That's kind of where it's coming from, the per violation component. I would also add, though, that in these instances, injunctive relief from a practical matter would be very scary for institutions because the Department of Education is responsible for determining who can administer Title IV funding. So if injunctive relief is that they cut off that valve, I think that fines would look much better than that. Obviously, we never want to be in either situation, but I do think that's an important distinction on that piece of it, Pete.
Yeah, that's good.
So we've talked about breach reporting obligations presented at the FSA conferences and some questions that we have about those expectations. So now let's look at some of the practical considerations when you're in your breach analysis, or better yet, as Pete has said a couple points in time, when you're thinking about how you will handle a breach before it occurs. First, your institution, as we continue to say here, we need to comply to the maximum extent required by the law. If not, you could get fined or worse, the determination that you're incapable of administering funds. We all know that. As we work through this, and you've seen our updated breach checklists and compliance checklists, we recommend that you get your legal team in these discussions quickly. As Pete said, for one, there's going to be some attorney-client privileges that attach to those communications. And more importantly, you're going to need to understand the boundaries of the law, the risks of what's associated with your determinations, and how you're going about this and what you're doing. Just as a quick example, Pete provided the FBI example. We've been kind of apprised of another similar type of conflict between various laws. One of them, which involving a VA audit, and it's, from what our understanding, it's not expressly stated in FERPA that the VA is authorized to audit student records. So under a strict application of this position, it could be viewed that would be considered a breach. Practically speaking, there's no way that would be considered a breach, and I don't think anybody would think that. But when we get these conflicting laws, there has to be a determination that it's okay. We understand that that's being analyzed, and those are the types of things you'll want to be contemplating as you move forward with this, without the true kind of a true framework on how to apply every issue. I also think it's important to talk about that there's really a spectrum of sensitive information, and we alluded to this a little bit earlier. And we're trying to prevent cyber crimes and identity theft. The urgency of the notification depends on the type of information at issue. Like we said, if it's password to FSA systems, then my first call would be to pick up the phone for the information provided to the department and let them know immediately that we have an issue so that they can help us stop that. if Pete said employee W-2 information seems a little bit different, and there's already a very robust reporting framework and an investigation framework around that type of information. So you want to have stakeholders, from across your campus involved in this, including your chief information security officers, your legal counsels, to get weighing in on these questions so you can make informed decisions and make the right decisions.
Can I go on a frolic and detour with one of the points that you just made? We've worked obviously with a number of clients to help them set up policies and procedures to comply with these requirements. But obviously, as you just articulated, there's an element of the unknown here with respect to what to do and when to do it. But I think we need to communicate to the audience that the approach that we've taken, or the mantra that we've used in terms of structuring those policies and procedures, is really to focus on what is reasonable. And for the lawyers who are listening in, our compliance stance is really driven by the Chevron line of cases, which essentially say that in the absence of a clear, unequivocal agency guidance, a regulated entity shouldn't be penalized for past actions as long as those actions were reasonable and then based on the guidance that was then available. So, again, reasonableness drives everything as far as I'm concerned when it comes to complying with these requirements.
Yeah, and it's a conundrum. Candidly, it's a conundrum. So I agree with Pete on that. So we're going to now shift gears, and we just talked about the breach reporting obligations or expectations, and now we're going to talk about compliance with the Gramm-Leach-Bliley Act. And to kind of try to keep these two topics in perspective and understand how they work together, breach reporting would basically be a small subset of the overall GLBA compliance framework. And so that's kind of how that sets up. I think Ed has articulated an increased focus on GLBA, but it's certainly not anything new. And I suspect most of the institutions already know these things. You'll see that the dates on some of these documents are older. First and foremost, we all certify that we comply with GLBA in our program participation agreement, so that's happening on a regular basis. Also, there was a Dear Colleague letter in 2015, 2016. I won't go through the specifics of all those documents, but they certainly, voice the expectation that all institutions are complying with Gramm-Leach-Bliley, data privacy, data security in general. And then this summer/fall is when kind of the audit information came out, but it's not really unexpected from that standpoint. This leads us to our next poll question. Interested to see the results here. Is if you were previously aware that Ed intended to enforce GLBA compliance in 2018.
So while everybody's frantically clicking away on this poll question, I just mentioned, to the extent I haven't done it already, that enforcement of GLB is, by statute regulation, limited to the FTC, federal banking authorities, and state departments of insurance. So as such, we need to just remember that Ed's authority to audit, enforce with respect to GLB is really viewed as a contractual arrangement rather than something that is tied directly to a statute or a regulation. At least that's my view on it.
I think it's a good point from a pure legal debate. I think, as you said, though, is there any practical difference? I don't know, and I don't know if you have an opinion on that or if you agree on that, but is there a difference? So we're getting our responses in. So we're about 50-50 here, a little more no's than yeses, which is what we would expect, that this is more well-known. And part of it could be the way we phrase this, since it's not that GLBA applies, but whether the audit is going to occur. And that's what we're going to kind of give a background now, a little bit of GLBA, so we're all talking the same language here.
And that's essentially, I can rip through this information pretty quick. So what is Gramm-Leach-Bliley? We've been referencing it for a while now, and I think it's about time we gave you all a bit of a backstory on the law. So GLB was passed back in 1999, to enhance efficiency and operations within the financial services industry. And as a function of creating those efficiencies, financial institutions were given access to a large amount of customer data. And once you get access to customer data, you run the risk of credit fraud, identity theft, bad things along those lines. And because those bad things were then brought to the fore as a result of this access to data, this in turn required financial institutions to put in place administrative, technical, and physical safeguards to protect the privacy and security of the customer information that they handled. And for those of you listening in who may be affiliated with institutions that educate healthcare providers, boy, this sounds a whole lot like HIPAA, Health Insurance Portability and Accountability Act of 1996, which began as a law to ensure health insurance portability, but then kind of morphed in over the years to a law that addresses privacy and security. So with that, let's parse some of the language of GLB. First off, that first underlined term in the previous slide was financial institution. And to the uninitiated, it seems like a bit of a leap to throw colleges and universities into the same bucket as a financial institution. But we shouldn't forget that fact that the law, as originally drafted, was confined to financial activities that the Federal Reserve Board were determined or had determined were closely related to banking and or the controlling or managing of banks. So from that, over time, we've expanded the scope of the application of GLB to, and this has been interpreted by the FTC, and I think, Sean, you are going to comment on this a little bit more fully, but the FTC has applied GLB directly to colleges and universities, and the nexus there is the administration of the financial aid. So we're there. It's an accepted tenet, GLB, that it'll apply to colleges and universities. So second underlined item on the slide, or that previous slide, was customer information. And customer information includes non-public information that's collected by a financial institution, in this case a college or university, in association with providing a financial product. The critical element here is that the information must not be publicly available. That means that the information, if it could be gathered through a Google search or a phone book, to the extent anybody uses phone books anymore, it's not covered by GLB. And that makes sense because that type of public information, readily available information, standing alone doesn't really carry with it any risk of credit fraud or identity theft, which is really the driver behind these compliance requirements.
Kind of that increased likelihood of misuse.
That is exactly it. Well put. Oops. All right. Let's dive into the two essential components of GLB compliance. With those financial institution and customer information terms identified, understood, out of the way, let's talk a little bit about how the structure of privacy and security compliance is set up under GLB. And, I mentioned already, for those familiar with HIPAA, boy, this looks a lot like HIPAA in that we've got privacy and security rules. And basically, in order to meet GLB requirements, an institution obviously has to meet both those fronts. They go hand in glove. Fortunately, the FTC, and Sean, I think you may have alluded to this earlier, has provided an exemption for colleges and universities that comply already with FERPA. The exemption applies to the privacy rule. Unfortunately, the exemption does not apply to the security component of GLB.
And I'll just add that means that you're actually complying with FERPA, though.
Point well taken. So anyway, let's talk a little bit about that safeguard rule since we don't have that direct exemption. To those who are well-versed in privacy and security compliance, these requirements that we've thrown up on this slide shouldn't come at you as a surprise. The overarching goal is to adopt policies and procedures and practices and protocols to implement measures to secure and keep your customer information or keep customer information confidential and secure. And this is done first and foremost by identifying through security risk assessment any anticipated threats or hazards and then mitigating those risks. So you kind of view that as external controls. And then it's also done by protecting against unauthorized access to information, which could result in a risk of harm to the affected individual. And think about that kind of as an internal control. And as a point of interest, we talked about this earlier. I don't know where else to comment on it. I'll comment on it here. But GLB does include, it specifically allows for a law enforcement delay. That's a point we called out earlier. So I just find that kind of curious in terms of this is the structure, yet it already has baked into it an enforcement delay. So that's the skeleton of GLB compliance. And I think Sean's going to discuss how that has added some flesh to those bones. So I'm going to turn the mic back over to you, Sean.
And I'll also just point out that the GLB also kind of contemplates that reasonable analysis of misuse within kind of its framework as well.
Right.
So this is the proposed audit language that's available, and you'll be able to access this language to a link later in the slides, and I'll show you where that is. But this is the proposed audit language that's published on the website. And as you'll see, it really tracks the safeguards rule. They want you to verify. They want to verify that you've designated an individual to coordinate the information security program. They want to obtain your risk assessment and verify that you're addressing the issues outlined in 16 CFR 314.4b. And then obtain the documents that show what you're doing to mitigate those risks and verify that the mitigation efforts are working and that they don't need to be tweaked to protect information more thoroughly. Wanted to provide you with the express language of 16 CFR 314.4b. Again, really tracks the safeguard language that Pete was talking about. Training and management so that all your employees know what your policies are and what they should do to help protect sensitive information on your campuses. Identifying what your network systems look like and really understanding the vulnerabilities there and the risk that could be associated with those, and then taking steps to detect, prevent, and respond to attacks. So that's kind of the components of that.
Before we go on, there are a lot of words on this particular page, but I think they all basically distill down to essential cybersecurity compliance principles. You conduct a risk assessment, you identify gaps, you address those gaps through administrative, technical, and physical safeguards, and then you train staff on those safeguards, usually through policies and procedures. And then once you finish it, you do it all over again. And frankly, this needs to be, in my estimation, as a best practice, undertaken on an annual basis.
And when you listen to the slides, Ed would agree with that assessment, and also with the particular emphasis on the training, that it's not just to have these policies sitting in a desk somewhere. They want to see that you're implementing them. We know that all of our institutions out there do lots of training, back-to-school trainings, and there's other great opportunities that you can utilize to satisfy that obligation.
Want me to take over the con for a moment?
Please.
All right, let's get practical, folks. What do you need to do to get into a compliant posture with respect to this proposed audit language? Well, first thing you need to do is designate a CISO. Whether that person is an actual CISO, it doesn't really matter. It's not the job title, it's the job description about which we're concerned. So it can be a CIO, a compliance officer, another individual who is trained in privacy and security, or specifically here, information security compliance. The other thing I'd point out in second is you need to put together a written information security plan, which should, not can as we say in the slide, but should include an identity theft protection program. We're going to talk a little bit about that later when we get into some red flags issues. Third and fourth, conduct the risk assessment. We already call out that issue, and respond to identified gaps. And then finally, document everything from the risk assessment to the remediation to the policies and procedures to the sign-in sheets for the training session. The department, and frankly any other agency that's out there that regulates the privacy and security space, is going to want to see that documentation in the event something bad happens and they have to come in, or frankly, even if something bad didn't happen and they're just simply auditing.
And it's way easier, as many of you know, to just be able to pull out the file, set it on the desk, and be done with it, as opposed to try to gathering a bunch of information when you hear that somebody's coming. So let me talk a little bit about the Chief Information Security Officer obligation. This is coming from the presentations, and candidly, this is some pretty low-hanging fruit to be in compliance. Is number one, it's got to be a current employee with appropriate knowledge and authority. Basically, it's someone that can make sure that data privacy, data security is being taken seriously on your campus, and is bringing these issues to the high-level administrators on your campus, and that they're all aware of that. Because as the presentation has stated, the letter, if there's a breach, if there's noncompliance, the letter from Ed, if there's noncompliance, is going to be directed to the president. And they also expect board to be accountable for noncompliance. So they're looking at this as a top-level institutional issue that all campuses need to be taken seriously, and putting that person in the right level of the organizational chart is important. And then another simple thing is identify, so that all of your employees know who that Chief Information Security Officer is, who they can go to with questions, who they can go through for training, and in the event that there ever is an issue, who they contact, so it gets escalated immediately and the proper policy can get in place, and we can get moving quickly.
Sean, real quick, just a couple of comments here. That second bullet point that you have really speaks to information or institutional governance issues. And specifically, most organizations, most institutions have heat maps, enterprise risk management heat maps, which assign risk to certain issues based by the organization. And in my experience, in almost all cases, information security breaches end up in that upper right-hand corner, and they're in red. So it is kind of a make-or-break risk issue for most organizations. And one way to really get a handle around that and address it is to make sure that not only do your staff, your employees, undertake training, but also the board undertake at least a basic level of privacy and security training to sensitize them to the issues and also allow them to better govern that risk.
And I'll also add that we know that there's an expense to all of this. It's expensive to add new compliance. It's expensive to add these new things. Having your board on board may help with that. Your presidents, your leadership councils maybe will help with that. And it's also, if you have a plan in place to get compliance over a period of time, is much less expensive than when somebody comes in and says it's time to do it right now. We gave some examples of that in our previous breach presentation that some of you may remember, so I won't go over in detail, but we all know that that's the case. Our last poll question, how many of your institutions have written information security plans in place, or that you know of? All of these answers are anonymous. We don't do anything with this information, so you know. So just wanted to kind of gauge where our listeners are at. So it's a good time to stop. It's a good percentage point for it. 82% of you already are doing this. That's great. Glad to hear it. I know that the Department of Education will be very happy to hear that as well. If you answered no to this, you need to get the information security plan in place quickly. This is kind of a template of how we would structure that document. I'll say that we're calling it an information security plan here because that's the nomenclature that's being used. I really look at this much more as a policy, kind of an outward-looking document that other folks would see and be available to. But that's what it's being called, so that's what I would call it. You want to state the objections, the objective and the purpose. Very typical policy. Define what information is subject to the policy. Scope it. As Pete said, require annual review. Identify the Chief Information Security Officer. Kind of start identifying your risks and how you're mitigating those, and then outline your breach response instructions. If you're already doing that and you click yes, you might want to think about kind of moving into the comprehensive written information security plan realm, which you have your ISP in place, which is your policies. Your comprehensive written information security plan, or your CISP, is really kind of the hard work behind it and shows that you're incorporating and executing your plan. So I'll go ahead and move on to the next slide. Kind of getting low on time here, I know, and we've got just a couple slides to finish. I referenced the slide earlier. This is from Ed's page, and they put together some tools to help identify risk and some of these other issues we're talking about. The proposed audit language is on this page, so please look at this page. There's some great materials on there that you can use to kind of tailor to your institution. They're great starting points. One thing in particular we want to point out is the assessment tool, the cyber assessment tool that was prepared by the Federal Financial Institutions Examination Council. They have on that site, it has basically been digitized, and you can run some different analyses, and it'll tell you your risk profile, your cybersecurity level, and kind of help you identifying your risks, how you need to address those, and what you need to do. It's a great, another free tool on the website.
Red flags. Not much to say here, but because Ed mentions it, references it in its presentations and guidance materials, we feel obligated that we have to at least mention to you also that the department expects institutions to communicate its efforts to combine or combat identity theft in its written information security plan that Sean just outlined. That said, identity theft red flag rules are somewhat old school. They've been around since 2007 when they were promulgated by the FTC. They don't make it into the privacy and security headlines all that often, especially these days. But notwithstanding, identity theft protection is critical. And if you think about the Equifax breach and all the concerns that caused, and as such, they really should be part of your ISP, and they need to be labeled as such. Years ago, I was working with an institution that was being surveyed. It had produced stacks and stacks of materials in response to a data request from the surveyor. Surveyor got all those materials, got all that information, and responded to us, "Don't make me work." So since then, our maxim has been, don't make the surveyor work. And so we heartily recommend that if there is a requirement in the regulations, and we've addressed that requirement in our policies and procedures, we label it as such. And with that, I think we've got one slide left, Sean.
One last slide, and I know we're running out of time, but we wanted to touch on this because as you listen through those presentations, to the extent you do, one of the things that they do bring up are these third-party agreements. We know our institutions utilize third-party vendors all the time for a variety of reasons, and commonly there is a sharing of information that occurs as part of those agreements. It's critical to understand that we cannot contractually kick any of our obligations to the department or Ed to a third party. We are responsible for reporting to Ed any breaches or security issues. We can try to weave in some indemnification requirements for the third-party vendors to the extent that we are fined or anything else, but it's ultimately our responsibility. And the big point that they were trying to make there, we could do a whole other presentation on third-party agreements, and we work on those all the time, but the big point they're trying to make there is you need to contemplate your obligations of breach reporting and compliance in these documents. because if you're, commonly they'll say 45 days the vendor has to tell you if they know of a breach. Well, if they don't have to tell you for 45 days, how are you going to put Ed on notice within a quick amount of time if it's necessary? So just think about that. And as a practical pointer here, when I'm working on these, I've gotten a lot of pushback from vendors on this recently as we try to incorporate this into our agreements for our institutions. I send them the presentations and just say, this is what we're dealing with, this is what we're trying to contemplate, and this is where we're at. So frequently they'll be okay with that. So with that, I know we missed some questions today. We tried to answer some in our presentation as we're going through. Those that we didn't answer we'll be following up with. But we want to thank you very much for joining our program today. We hope the information provided was helpful to you and your organization. If you've not already done so, please click on the survey icon at the bottom of your screen to complete our short survey. Your feedback really assists us in providing quality future programs. As a reminder, the program has been approved for Colorado, Illinois, Iowa, Missouri, Nebraska, Tennessee, Texas, and Wisconsin continuing legal education credit. A recording of the webcast will be available tomorrow for watching and sharing. Once available, a link to the recording will be emailed to you along with a certificate of attendance. The recording will be available for 2 weeks. Please be sure to join us for our next webinar on February 27th. Julie and Ashley will be talking about minors on campus. This concludes our webinar. Thank you very much.